Hey everybody, I'm Max Pines, attorney at Max Pines Law. I do criminal defense and civil rights here in Albuquerque, New Mexico, and all over the state. I want to talk to you all today about pretrial detention and the answer to everyone's question when they have a serious criminal case, which is, am I going to be getting out of jail? Because let's face it, the question of whether somebody gets out of jail or not pre-trial, whether they have to stay in jail pending the case, is such a crucial question, and it really changes the trajectory of the case in general. We as the defense, we have such a problem of leverage. If our client is stuck in jail pre-trial, it diminishes our ability to investigate, and it just makes it so hard. And we can't underestimate the price of that deprivation of liberty. So instantly, whenever I have a client, a family member of a client, a friend who, they have this case and they want to know, am I getting out of jail? And the answer is typically yes. And the answer is yes because just over 10 years ago, New Mexico, we amended our state constitution to guarantee pretrial release. It used to be a question of you're going to get arrested, you're going to be given a bond, and that would be an arbitrary amount, and you would have to come up with some number of money, some amount of cash, a surety bond. You'd have to go to a bail bondsman and put up that money, and if you don't, then you're stuck in jail. But that was outlawed. That was changed. Except in unusual circumstances, the strong preference in New Mexico is pretrial release. And in fact, you're guaranteed that pretrial release unless the prosecutor files a motion for pretrial detention. Very important. The motion for pretrial detention is a choice that the prosecutor makes if it's a serious case, if it's a dangerous case, or if there's a bunch of other cases already filed. The prosecutor can file that motion. It takes it to the district court. It pauses the proceedings, and you have to stay in jail until we get to the pretrial detention hearing, which I can't underestimate what a crucial hearing that is. You need to get there with your lawyer. You need to get as much mitigating evidence in front of the judge as possible, a great treatment plan, a plan of how everything's going to be safe, how you're going to stay out of trouble. Because if that motion is granted by the judge, then you are going to have to stay in jail until the case is done. And you can move for reconsideration, but that's a heavy burden. It's a high hurdle to get that reconsideration. It's difficult to change the status quo. So you need to show up to that pretrial detention hearing ready to prove that there are conditions of release that can keep the community safe and get you into some treatment. But that's the exception. That's when the prosecutor does file that motion for pretrial detention. Because if they don't, the judge at your felony first appearance is obliged to release you. You might have to go to pretrial services. You might have to do some supervision. Important that we have this constitutional right to pretrial release. It really authenticates and exalts our constitutional right to be presumed innocent. And that should be the default. And under our New Mexico State Constitution, that's true, because you will be released as long as the prosecutor doesn't file that motion for pretrial detention. And it's so important to be able to be out and have that presumption of innocence and be allowed to work effectively with your attorney pre-trial in order to construct the best defense possible. I really appreciate you listening. If you have more questions, I have a lot of information on my website, maxpineslaw.com. A lot of important topics in criminal law, and please take a look at it, and I appreciate your time. Hope you have a great day.